Thanks for tuning in. I'm Scott Walter.
And I'm Michael Watson.
After a big June of victories for the First Amendment at the Supreme Court that now has a freshly open seat on its bench, we are joined by Lorie Windham, senior counsel at Becket Law, to go behind the High Court's famous red curtain and discuss just how these crucial cases are argued. This is the InfluenceWatch podcast. In a Supreme Court term that closed last month, First Amendment free speech protections won 3 major victories against efforts by so-called progressives to compel dissenters to mouth agreement with or to fund support for the left's values. Those 3 victories provoked the New York Times to complain in a front-page article that pretended not to be an editorial that conservatives were, quote, weaponizing free speech. 2 of the cases, the Masterpiece Cake Shop dispute over a wedding cake, which we discussed a couple of episodes ago, and NIFLA v. Becerra, which challenged a California law that all but required pro-life pregnancy centers to advertise for state-funded abortions, dealt directly with religious freedom. And so we're happy to welcome Lorie Windham, senior counsel of Becket Law, also known as the Becket Fund for Religious Liberty, which filed friend of the court briefs in both those cases. She'll help us discuss the Supreme Court's decisions and how influencers like Becket organize to win big decisions like these. Okay, so Lorie, the first thing I should say is disclosure that years ago I worked alongside you at Becket. I also want to point out that you're a Harvard Law School grad and that in your career you have defended a very wide array of different religions, correct? I mean, Becket is not simply a defender of Christians in the courts, is it?
That's exactly right. We like to say that we defend everyone from A to Z Anglicans to Zoroastrians, and there's an important reason for that. We believe that religious freedom is not something that just belongs to you or to me or someone who believes like us. Religious freedom is a fundamental human right, and it's something that must be defended for all faiths. And so that is what we aim to do at Becket, and that is what we have done at Becket.
Another thing that is distinctive about Becket is that while many firms that are similar get into other areas besides religious liberty, Becket stays laser-focused just on religious liberty. Isn't that correct?
That's exactly right. And Becket is small by design. We want to be the people who can go in and find the right case in the right place and take that and set a good precedent. And so our job is not to try and cover the whole panoply of cases out there, because you'll tire yourself out really quickly doing that. There are a lot of interesting issues, but to focus on one thing, which is religious freedom, to know the law of religious freedom and to do that really well. And so if we are to divide our focus and do other things, we'll be less effective. And I think our effectiveness speaks for itself. We are 5-0 at the Supreme Court and hope to keep that record running.
Yeah, batting 1,000 at the Supremes is not bad. Well, Mike, why don't you get our discussion started with a recap of some of these decisions?
So the first case that was decided, Scott, you and I discussed a couple weeks ago, and that was Masterpiece Cake Shop v. Colorado Civil Rights Commission. And the question that was posed in that case effectively was, can a religious Christian baker be compelled by state non-discrimination law to make a custom cake celebrating a same-sex wedding? And the court ruled by 7-2 that they aren't really sure, but man, the Colorado Civil Rights Commission was really mean to religious people. And therefore, the baker must be allowed not to be punished.
Yes, and as I recall, Lorie, the baker made it clear that he wasn't saying there were classes of people he would refuse to do business with. He was only saying that there was a particular ceremony that he wouldn't bake for. Am I right?
That's exactly right, and that's where religious freedom arguments really come into this, is he was saying, hey, look, if you want to come into my shop and just buy a cake off the shelf, here are all the cakes. I'll happily sell you one. It's just that I can't participate in and celebrate a religious ceremony that is contrary to my beliefs. And we have a long history in America, and this was recognized in the 7-2 opinion in this case, that we don't coerce people to participate in religious ceremonies they disagree with. The majority opinion talked about the fact that clergy can't be coerced into officiating at a wedding at which it would be contrary to their religious beliefs. And it's interesting to note that when clergy are doing that, they're also doing that on behalf of the state. They are actually participating and signing the marriage license for that couple. But even in that role, they don't forfeit their religious freedom, and they can continue to follow their religious beliefs. The same should be true of a baker who's just trying to live out his faith.
Now, Mike, the next case we want to talk about is the NIFLA v. Becerra case. Tell us the background.
So like Masterpiece Cake Shop, this was also a compelled speech contrary to your religious beliefs situation. What California did was they passed a law that, to put it simply, basically compelled pro-life groups that operate crisis pregnancy centers to advertise for this state's publicly funded abortions. Needless to say, when you are a pro-life institution who is opposed to abortion and exists to persuade women about alternatives to abortion, and the state comes in and says, you have to advertise our publicly funded, taxpayer-funded abortion services and quote-unquote family planning services, that implicates their religious freedom. And so the National Institute of Family and Life Advocates, which is a group
NIFLA.
Which is a group that, an association of these pro-life crisis pregnancy organizations, sued the state to protect the freedom of these pro-life pregnancy centers to operate in accordance with their beliefs. And it made it all the way to the Supreme Court, and the Supreme Court ruled by a very tight 5-4 decision, which is kind of scary, that absolutely not. The state could not force that medical professionals do not lose their religious freedom when they are working as medical professionals, and even the non-licensed pregnancy centers, the rules that were put on them were also overly burdensome of their speech.
Yes, so Lorie, that's right, isn't it? That the court's decision in this case was based heavily on the free speech part of the First Amendment.
Yes, that's exactly right. And what the court did there was something that's really important, and I think we'll see will apply more broadly. Is it said that when you are talking about a content-based speech regulation, when you are restricting someone's speech because of its content,
and it was very clear in this California law that it was targeted directly at these pro-life institutions.
That's exactly right. And when you are doing that, the government is going to have to face strict scrutiny, which is the highest legal test there is. What's interesting is the Supreme Court didn't go back and say, no, we have to look at the legislators' heart of hearts and know if they were really meaning to discriminate against pro-life pregnancy centers. They said, look, if it walks like a duck and quacks like a duck, it's probably a duck. And so if you have a law that is targeted at a particular type of speech, that law is going to have a very difficult time proving that the government will have a very difficult time proving that law is constitutional.
And in the 5-4 decision, who wrote the majority opinion?
That would be Justice Kennedy.
So, and as I recall, this is the case in which he is himself a Californian, and he seemed to be especially tough on his fellow Californians in this matter, and in fact upbraided them, saying that the way to go forward is to go back and look at the original First Amendment. Is that correct? Was that somewhat surprising?
Kennedy wrote that. That was a concurrence. Justice Thomas wrote the majority.
You're right. My apologies.
Wrote the majority opinion, but Kennedy wrote a scathing concurrence, and of course Kennedy is from California, in which California likes to see itself as very progressive, very forward-thinking, very the vanguard of America, and Justice Kennedy was like, hey, wait a minute, it's not forward-thinking to make people violate their beliefs.
Yeah, so that for his the end, and of course he knew he was going to be resigning, so that was an interesting way to go out. Well, Mike, the third case that we want to talk about that's free speech related here is came down on the very last day, Janus v. AFSCME. Tell us who AFSCME is and what was the case involved.
Even religious liberty comes back to employment law. The American Federation of State, County, and Municipal Employees. So Illinois and 21 other states had, until last Wednesday, a provision in their law which required government workers who are represented by a government worker union, like the American Federation of State, County, or Municipal Employees, to pay what are so-called agency fees, to pay the union that you don't want to be a part of and that you aren't technically a part of, but that represents you because it's a union privilege that the unions have under state law, to do the work of the union. And Mark Janus, who is an Illinois public worker, sued, saying that that violated his free speech rights, that was improperly compelled speech. And by a 5-4 ruling authored by Justice Samuel Alito, the Supreme Court agreed.
Yeah, so all three cases then are about compelled speech, the baker being compelled to express himself, the pro-life pregnancy centers being compelled to essentially advertise their competition, and Mr. Janus being compelled to have a union speak for him when it in fact did not speak for him. Well, Lorie, was Becket active in these cases, and if so, how?
Yes, we were active in all three of these cases. We filed amicus briefs with the Supreme Court in all three. And the value of doing that is you can bring different arguments to the court's attention. You can also bring different situations to the court's attention. For example, in the NIFLA case, we represent two pro-life pregnancy centers, one in California and one in Baltimore. And so we're able to talk about the fact that these laws are not just something that were happening in California. There are different flavors and variations of these laws in places across the country. And they have different impacts, but they all have the same goal, which is to compel and restrict the speech of certain pregnancy centers whose values are disfavored by state legislators or local officials. And so we were able to tell the Supreme Court a little bit about some of the other cases on the horizon and the fact that this is not an issue that is being decided in a vacuum, that in fact there are a number of these laws across the country and their decision here is going to impact a number of different jurisdictions across the country.
So now that the court has handed down the NIFLA decision, how do you think that will affect some of the cases that you have currently underway in other jurisdictions?
Well, we're very hopeful that we will see good decisions in these cases going forward, especially because the Supreme Court has made it clear that you can't go out to target a particular type of speech and get away with it. In fact, the Supreme Court refused to review the good Fourth Circuit decision that we had in our Baltimore Pregnancy Center case. And so we were very happy to see that they'd taken that step. And we think that going forward, the lower courts are really going to struggle to uphold these sorts of restrictions on pro-life pregnancy centers, given the very strong statements that were made in NIFLA.
Well, that's fascinating. Now, you said in these cases you participated as a friend of the court, the amicus curiae style brief. For those of our listeners who haven't worked at public interest law firms, explain a little bit about how, why do we bother to have these amicus briefs? And by the way, Becket was by no means the only person participating, correct? Tell us a bit about how both sides in big fights like this strategize and collect allies and how it all works.
Certainly. This is something that has really proliferated in the last few years of the court. The tradition of filing an amicus brief goes back for many years, but in the last few terms we have seen more and more of them. And what happens is that advocacy groups on both sides will show up to make their arguments. And they have the advantage in doing that in that they can make different arguments from the ones that the plaintiffs and the petitioners and the respondents are making. They can bring other cases to the court's attention. This is kind of the traditional historical purpose of a brief, is to say, hey, I have an interest in this case. I have something similar that's going to be impacted by this. You need to consider my case too when you're thinking about this ruling. And so they can bring those to the court's attention. They can have briefs by scholars or experts in a field who can bring issues there to the court's attention. And it's very important because you know that the other side of a case is going to be doing this. They are going to be trying to rally amicus support from their side. And so it's very important to be able to rally amicus support to show that you're not standing out here alone, that there are a lot of people who are interested in this issue, a lot of people who care about this issue, and a lot of people who want to see the Supreme Court rule in the same way.
Who are some of the folks in NIFLA or other cases, some of the other groups that Becket often has, roughly speaking, allied with it in the filing of these kinds of briefs? Well,
you certainly also see a number of different religious liberty organizations like ADF and First Liberty. Heritage Foundation, while it does not actually participate in filing amicus briefs, will often have experts who help to support different amicus efforts. And you'll see ACLJ, other religious liberty groups. You'll also see a number of different religious groups, groups like the Conference of Catholic Bishops, the National Association of Evangelicals, the Orthodox Union for Jewish Groups. You'll see a number of different large religious organizations who will come in and weigh in to explain how their religious freedom rights may be impacted by the ultimate decision in this case.
Thanks. Well, and Mike, there's no shortage of folks trying to influence the other side, and of course all these groups you can look up on influencewatch.org for more information, but tell us about some of the big ones on the other side.
So I'll start with a history lesson. The whole enterprise of public interest law, which is what Becket and groups like it do. They advocate obviously on behalf of clients, on behalf of individuals, but there is a broader public purpose. For Becket, it is to protect and defend the First Amendment religious rights of whoever they're representing. For a group like the Mexican American Legal Defense and Education Fund on the other side, it may be to protect privileges for immigrants or to secure some voting protection. This whole enterprise is generally credited by people like Walter Olson, who's written for the Cato Institute scholar, who's written for Capital Research Center on occasion, is generally credited to the Ford Foundation back in the late 1960s. The Ford Foundation was, until very recently, the largest foundation in the country. It is one of the largest funders of progressive and liberal organizations across the spectrum: labor, civil rights,
Women's studies in universities.
Women's studies in universities, civil libertine groups, and a number of the original left-wing public interest litigation groups. I mentioned MALDEF, Environmental Defense Fund, Earth Justice, got their start with Ford money back in the late 1960s. And originally there was some question as to whether public interest law would even be allowed. The sort of funding of public interest law would even be allowed.
Yes, I highly recommend everyone go read Walter Olson's write-up on this in capitalresearch.org. It was taken from his definitive history of law schools, and the tricky thing was that the 501c3 statutes that allow there to be tax-exempt organizations, there had never been traditionally these kinds of public interest law firms who were out there suing people with strategic public policy goals. And the Ford Foundation was genuinely worried that the IRS might say, this just isn't a legitimate charitable effort. Suing people traditionally hadn't been considered a charitable act. So it was a complicated question. And intriguingly, it was done, again, it's late 60s, early 70s, this is happening, and the Ford Foundation was very savvy. They foresaw this issue. They got the current, and I believe it was 9 prior American Bar Association presidents all lined up to say this is a wonderful thing. I don't know why.
I'm shocked to discover that prominent lawyers believe that suing people is a good thing.
Yes, well, and that more jobs for lawyers would be good. But so they got that, and it was a very iffy thing in Olson's account in the Nixon administration whether this would be approved. But interestingly, Donald Rumsfeld was a crucial White House official at the time, and weighed in on behalf of the legal effort. Now, of course, this being America, once the principle was established that you could have a charitable public interest law firm, then, of course, you began to have a wide variety of different views represented among public interest law firms. So that's a classic American story in a way. But let's go back to the Masterpiece Cake Shop case, though, Mike, and the ACLU, which is arguably the very first public interest law firm predating that time.
Yeah,
they were mixed up in that,
one of the biggest advocacy law firms of them all, and probably the first. You're right. The ACLU actually represented in Masterpiece Cake Shop the couple who initiated the Civil Rights Commission proceeding against the baker, and in that they had quite a bit of support, obviously from groups who kind of expect the broader LGBT advocacy community. What you might not expect, you have professional associations. You mentioned the American Bar Association involved in the development of public interest litigation. The American Bar Association is a very powerful advocacy group in its own right. It heads a monopoly still over accrediting law schools. Is that correct?
Absolutely.
That's right.
Obviously, until fairly recently, I mean, it still rates judicial nominees, but until very recently, it had a direct line to pre-vet judicial nominees. The Trump administration stopped that early in its administration, but so very powerful advocacy group. And then you also had, unsurprisingly, the Freedom from Religion Foundation, which is a militant atheist, anti-religion advocacy group. And then you also had sort of broader liberal and left-wing organizations like the Service Employees International Union, Labor Union.
And the American Psychological Association, and which reminds me actually of something Becket was involved in some years ago, and it goes to this accreditation issue. I actually, because when I was paying my debt to society by serving on the Domestic Policy Council at the White House back in the second George W. Bush term, I actually read every word of the statutes on higher ed accreditation.
My condolences.
Yes, well, it was quite terrifying because for those of you who know public choice theory law, which is crudely put that government and all entities try to abuse government to protect themselves and hurt any potential competitors.
And government will happily aggrandize whatever power it can attain for itself.
Yes.
That's true.
So the accreditation laws are unbelievably perverted to defend existing accreditors of all things higher ed. Now that's for all of higher ed that gets very complicated, but let's just focus now on the Bar Association and the Psychological Association. The Bar Association is the only accreditor for any law school in America, and even beyond that, let's say tomorrow afternoon there were a new accreditor, there's two huge problems. One is that it is illegal for a school to be accredited by two entities, so a law school would have to say, we don't care about the Bar Association's accreditation of us, we're going to go for the new guy. Extremely unlikely thing to happen, especially given the second obstacle, which is most states, not quite all, but most states in America require that you have a degree from an ABA accredited law school before you are even eligible to be considered to join the bar of that state. So it's absolutely impossible for there to be, under those laws, it's impossible for there to be a new accreditor of law schools. And the ABA actually is one of the most abusive accreditors on this. They are fiercely aggressive in requiring all kinds of affirmative action, reverse discrimination in faculty hiring and student admissions and the rest. But what Becket had the run-in with was the American Psychological Association. And that is, again, it's a nationwide professional organization, and it accredits graduate psychology programs all over America. And again, what you in most states have is you need to have studied at an American Psychological Association accredited school in order to become a clinical psychologist or a licensed social worker, things like that in most states. So that is an incredible monopoly power. I typically thought that the left was supposed to think that monopolies are a bad thing, but somehow these monopolies don't seem to bother anybody. In fact, hardly anybody knows about all this. But so the way Becket got involved with the Psychological Association, maybe a dozen or more years ago, was there was a push in the APA's membership to delete a little footnote that they had in their own rules for accrediting psychological grad programs. And that was a little footnote that said, you're not supposed to discriminate on the basis of religion and race and this, that, and the other, with the footnote saying, but you are allowed to, if you're a religious institution of higher education, you can take religion into consideration for hiring and admissions. And of course, obviously, if you were a Jewish school that was going to be teaching about psychology, you might prefer Jewish psychology professors. And as I said, there was a push among the membership to try to throw that out, which would have effectively changed what's permissible at every psychology program in America. Beckett's famous founder, Seamus Hassan, had a full and frank discussion with the leadership of the Psychological Association, and the footnote was not challenged, but that's the little thread by which, to this day, all of this is hanging, and that's a scary prospect, isn't it, Lorie?
Yes, it certainly is. This is actually something we talked about in our brief before the Supreme Court in the Janus case, because accreditors do have enormous power, and we spoke about the APA issue and also the Gordon College situation, where there is a threat to revoke accreditation from Gordon College because of its Orthodox Christian beliefs about marriage. And so what you have is these secondary powers who are not governmental actors, and the courts have not said are state actors, and yet they wield enormous power with the authorization of the government. And what we called it was coercion laundering. When you hide the source of the money, we call that money laundering. When you hide the source of the coercion, we call it coercion laundering. And that's exactly what the government is doing here. It is giving some power to a third party and then allowing that third party to place requirements on people the government would never be able to do directly. And that's exactly what was going on in Janus. That's what's going on with some of these accreditation issues we've seen pop up.
And yet, correct me if I'm wrong, I have never heard of any direct legal challenge to this kind of accreditation issue in any sphere. I don't know of any.
No, I'm not aware of any. I think it's all been, discussions within legislation and behind the scenes, but we have not yet seen a full-on court challenge to the powers of the accrediting agencies.
No, that's a shocking thing, and it's funny. I am so old that I can remember when it was very common to say, you can't legislate morality and don't impose your morality on me, and yet it sounds like the state of California, for instance, and the state of Illinois.
Once again, we have had a run-in with Barone's law, the principle that all process arguments are insincere, including this one, this time by the ostensibly libertine left.
Again, our bigger picture here that we're looking at is the whole First Amendment is highly controversial, it would seem. And again, I like to run through my little quick thing that the very first thing in the First Amendment, people often forget, but the first liberty there is religious liberty. And I think the First Amendment kind of makes sense in the way of, first, it mentions religious liberty, which is really freedom of thought, freedom of belief and thought and conscience. And then it mentions free speech, and then it mentions the free press and free association, and they sort of naturally flow from the thought all the way to speaking to then organizing as the press or
organizing in collective action.
Mm-hmm.
Yeah, to do that. And I think in America there still is a great support for the First Amendment, and yet the folks who are not happy about some of these decisions we've been discussing, including the New York Times, seem to think that it's a good strategic move to object to this First Amendment protection by the court.
Yeah, the New York Times on the front page last weekend ran this article which they claimed was a news analysis, and they based it off some paper. I think it was Alex Griswold of the Washington Free Beacon had a pretty good debunking of it a couple days right before the 4th, and it involved classifying the speech cases that had come before the Supreme Court in recent years, and then that it's the conservative speech is winning, and that's somehow bad. And of course the issue is that for a long time the left had a fair gripe that that conservative traditionalist institutions, conservative and traditionalist governments, things like flag burning bans, restrictions on assembly and protest, that those governments were infringing on liberal speech, and in some cases explicitly politically liberal speech. But in recent years, the right has sort of conceded to the old liberals of the 70s that actually you guys had a point. Actually, we do need this free exchange of ideas. We do need this free exchange of thought. And I believe it was Antonin Scalia who wrote the decision that overturned the federal ban on flag burning. Is that correct?
He certainly joined it.
He certainly,
he wrote it.
Yeah. Well, he certainly sided with it. But in recent years, of course, it's been the progressive left that has really aggressively, especially in this sort of compelled speech sphere, that we've been discussing today, where there's a law that you have to bake a cake celebrating a same-sex wedding even if you're a religious Christian, where you have to advertise for state-funded abortions if you're going to try to persuade women not to have abortions, where you have to fund a labor union that you would rather not represent you at all, that only can represent you as a privilege to the labor union to increase its bargaining power. And these regulations have had to be struck down by the Supreme Court, have had to go before the Supreme Court because they're now proliferating. And so a change from the left is winning free speech cases at the Supreme Court to the right is winning free speech cases at the Supreme Court, if anything, is because the left has started attacking right-wing speech.
Well, there's also the demographic question here, Lorie, that I wanted to ask you about, and that is that it would seem, this is actually somewhat controversial on how to interpret the numbers, but it is broadly believed to be the case that religious belief is diminishing in America. And leaving aside the question of exactly how accurate that is, to the extent there's anything to that, do you think that is going to affect the long-term prospects of the First Amendment's religious liberty guarantees?
I'm very hopeful about the long-term prospects of the First Amendment's religious liberty guarantees. I think it is true that we have seen an erosion of understanding of why these are so important. I think one of the most disappointing things I have seen just in the time that I have been doing this work is the erosion of support for the Religious Freedom Restoration Act. This is a law that had a broad coalition from both sides of the aisle. It passed the Senate unanimously.
Chuck Schumer voted for it. Chuck Schumer voted for it.
Yeah.
Chuck Schumer voted for it, and President
Clinton
signed it.
Exactly. This was seen as completely non-controversial. And of course, now when states try and pass their own versions of this federal law, they're labeled as discriminators and have other states banning travel and all sorts of other overreaching things in order to penalize states for doing this. And so what we've seen is an unwillingness to understand that religious freedom means people are going to disagree, and sometimes those people you really don't like are going to be protected by this law, and we're seeing less and less support for that, what should be a broad-based and fundamental American ideal, which is that we all have freedom, and yes, that includes the freedom to disagree with each other.
No, that makes sense, and that brings us actually to a final topic, and that would be the open seat now on the court, given that Mr. Justice Kennedy has announced that he will be leaving at the end of this month. And one of the persons on the short list to replace him, supposedly, is Amy Coney Barrett. And when she was up for Senate confirmation to the D.C. Circuit Court of Appeal, where she's now sitting.
Seventh.
Or sorry, was seventh? Not
I am almost certain it was seventh.
It was the seventh.
I apologize. Sorry, wrong appellate court. But when she was up for her confirmation on that, there were multiple senators who
infamously, Dianne Feinstein of California, reading from what was obviously a prepared set of questions, asked Coney Barrett, who is a practicing Catholic, "The dogma lives loudly within you."
Yes, as if there were. So do you have any worries, not just with her, but within whoever may be nominated to fill that seat, that their personal religious beliefs are going to be a source of controversy?
That's certainly something we're concerned about because we've seen it already with some of the circuit court nominees. Our Constitution has a no religious test clause. It is supposed to be blind when it comes to judges, just as justice is supposed to be blind, not considering the people before it, but considering the merits of the case. And so there is a real danger that rather than considering the merits of the nominees before them, we're going to see senators attacking them because of their religious beliefs. And I think that's exactly contrary to what our Constitution was created for.
Yes, and I would add, too, that the another senator who went after Ms. Barrett before she was elevated to the bench herself was the now disgraced Senator Al Franken, who's had to resign thanks to his little encounter with the Me Too movement. But he worked her and battered her over and over because she had once spoken at an Alliance Defending Freedom event. Now, ADF being another public interest law firm organization, and he hammered her over and over because ADF has been called a hate group by the Southern Poverty Law Center. Lorie, do you think that's it isn't certainly quite possible that any number of people who may get nominated to fill Justice Kennedy's seat will have spoken at an ADF event somewhere or been on a panel with an ADF lawyer?
Certainly. This is a group that defends religious freedom for Christians and has been active in this for many years. They're not a hate group, and the idea that you would list them on a list alongside the KKK is just ridiculous, and I think shows that this term of hate group is actually the thing being weaponized to try and penalize people who disagree with you. And so I think it's quite likely that we will see some more attacks along those lines from people who have spoken in front of very mainstream religious freedom groups and other conservative organizations who may find these attacks.
If there's one kind of element for hope in anticipation of those kind of attacks, I think especially after the settlement with Maajid Nawaz, the British politician who the Southern Poverty Law Center had accused of being an anti-Muslim extremist when he himself is a moderate Muslim is not a term I particularly like. I don't think it's very descriptive, but a non-extremist.
And practicing Muslim.
And non-extremist practicing Muslim who believes in the Islamic religion. And they called him an anti-Muslim extremist, and he sued them, and the Southern Poverty Law Center ended up settling for a couple $1 million. Now the SPLC has more money stashed away than I will ever see.
Yes, about $500 million sitting in its accounts, many of them offshore accounts. And again, go to InfluenceWatch.org for all the juicy details on exactly what sort of organization the SPLC really is.
But that whole the attacks on Nawaz and on Ayaan Hirsi Ali and others really did expose how extremist, how radical the SPLC is. And again, it's unfortunate that events late in 2017 sort of brought the threat of far-right extremism back and gave the SPLC like shock paddles that they didn't deserve. But there's certainly that they have taken steps that have pretty actively discredited them with people who are paying attention.
Yes, well, and I suppose we should also advertise our own episode a month or two back focusing on SPLC. I liked what Ms. Barrett said to Senator Franken as he kept battering her about how could you possibly be associated with these monsters. And she looked at him puzzled and said, well, they're currently co-counsel with Wilmer Cutler Pickering in a Supreme Court case, and I really don't think that Wilmer Cutler Pickering, one of the largest and most prestigious law firms in the country, would be co-counsel with a genuine extremist group. But of course, that didn't satisfy Mr. Frank.
And didn't they handle argument in Masterpiece?
Yes, they did.
So does that make Sonia Sotomayor and Stephen Breyer,
who voted with
who were the two that made the 5 + 2 = 7?
Yes, it was Kagan, but yes, same point.
Kagan. I'm sorry, not Sotomayor. Obviously not Sotomayor.
Yes, well, Kagan's actually has been interesting on the High Court. Actually, maybe this will be one of our last points, but you never know what your appointees are going to do, because in the Hosanna Tabor Lutheran Church and School, which was one of those 5 Supreme Court victories that Becket has had, Elena Kagan was surprising, given that she had been she'd been Obama's Solicitor General and then, of course, was his pick for the court.
Yes, and she criticized the SG's office because she said that what they were doing was saying that religious organizations had no more associational rights than a labor union. And she said that was amazing, and not amazing in a good way. And she ended up actually going with Justice Alito and writing a concurrence to this 9-0 opinion, talking about the fact that minister is a term that means different things to different religious organizations, and you need to protect people of all faiths. So I think it was really a strong rebuke of the position that the Obama administration took there.
Yes, and conversely, Mr. Trump can never be sure in the end whoever he nominates to fill Justice Kennedy's seat, what exactly will happen down the line. It's always a roulette wheel when you're nominating judges. Well, that is our show for this week. We want to give a special thanks to Lorie Windham of Becket Law for joining us. If you're listening to this on iTunes or Stitcher, you should know that we broadcast a live video version of the podcast at 10 a.m. on Thursdays, Facebook Live and YouTube. You can find our pages by searching Capital Research Center. And if you're watching the video version, I want to encourage you to subscribe to the audio on your preferred podcast platform. We'll see you next week.